Good afternoon to everyone present. I am Sivani, and today I'll be presenting on the topic arbitrability of criminal matters, where I'll be exploring the boundary between civil and criminal law in arbitration. So, first to understand the topic, arbitration is a private consent-based mechanism used mainly for resolving civil and criminal law, commercial law. On the other hand, criminal law deals with offenses against society and is prosecuted by the state. So the key distinction here is between private rights and public justice. Because of this, criminal matters are generally considered non-arbitrable. But in practice, the distinction is not always so clear. In real life situations, a single act can lead to both civil and criminal consequences. For example, a fraudulent transaction may result in criminal liability for cheating, while also giving rise to civil claims like damages or contract termination. In such cases, arbitration helps in separating the civil aspects like compensation from criminal punishment. This allows the parties to resolve disputes efficiently while the criminal process continues separately. This is where complexity of arbitrability begins. The Indian judiciary has gradually evolved on this issue. Initially, the courts took a strict view and excluded fraud and public rights from arbitration, as seen in N. Radhakrishnan versus Maestro Engineers. However, this approach was refined in A. Ayaswamy versus A. Paramasivam, where the court distinguished between serious fraud and simple fraud. This was further clarified in Avital Post Studio versus HSBC, where arbitration was allowed because the dispute was essentially civil. Finally, in Vidya Droila versus Durga Trading Corporation, the Supreme Court confirmed that matters involving public rights, including criminal offences, remain non-arbitrable. So today, courts follow a more balanced, substance-based approach. So this slide shows the actual interface between arbitration and criminal law. On the civil side, arbitration can determine contractual rights, award damages, and even examine issues like bribery, but only to assess the validity of the contract. However, arbitrators cannot impose criminal liability or punishment. On the criminal side, courts independently determine guilt and sanctions. So the key idea is that arbitration deals with civil consequences while criminal courts handle publication, punishment, and public justice. Despite the flexibility, there are clear limits. Serious offenses like murder, rape, terrorism, and large scale cooperation are strictly non arbitrable because they affect public order and require judicial oversight. There are also practical concerns like lack of procedural safeguards in arbitration, confidentiality, hiding misconduct, and power imbalances between the parties. These factors make it unsuitable for handling core criminal matters. Conclude, arbitration does not replace the criminal justice system, it just works alongside it. While courts deal with criminal liability and punishment, arbitration can efficiently resolve these related civil aspects. The law today aims to balance efficiency in dispute resolution with protection of public interest, ensuring that justice is not compromised. Thank you for your time.